Now, the courts have ordered, or rather ruled in favor of a marketing company called Ezulweni Investments in a long-standing battle with the ANC over election banners. This legal matter dates all the way back to 2019. That's where the ANC denied that it had officially requested election banners from Ezulweni ahead of the polls in that year. The judge, however, has found Ezulweni had a binding contract with the ANC and that the party owes millions of rand for the service. Let's get you more on the story, bringing the attorney representing Ezulweni Investments, that's Shafique Sarlie from Sarlie and Associates, joining us via our video link this morning. Great to have you on the program, sir. Thanks very much indeed for making time. You know, for some reason, the ANC doesn't think that it has any obligations to pay back this money, but at the center of it is 30,000 odd election banners valued at around 2,900 rand each. So let's begin with some context. How far down the agreement did Ezulweni go with the ANC?
Yeah, you know, we're looking at just prior to the elections where my client was contracted to do these banners. And we proceeded over the weeks after an agreement was concluded. We've got ample, and this is before court, in the papers that we filed in the application brought in the Joburg High Court, where we showed persistently the ANC would acknowledge that we were performing the contract. Indeed, it's never been their case up to the Supreme Court of Appeals that we had not performed. So they have received the benefit of the services. They contend that there was no contract concluded. They contend that the person seized with contracting with our representative were not duly authorized. Obviously, the various courts have rubbished that version, that defense, and here we are today where the Supreme Court of Appeals in a full court have given a judgment that overwhelmingly is found in favor of Ezulweni and have dismissed the appeal of the ANC.
Right. So to be clear, these banners did land up with the ANC and they were used during the election period?
Absolutely, absolutely. There is no challenge to that by the ANC.
Right.
That they received the services.
Part of what they said in their defense is that there are factual disputes. I presume you've outlined some of them in the form of this non-existent contract. But what are some of the other points of contention, at least from the ANC's perspective, who to this day maintain that they don't owe Ezulweni this money?
Well, Ayanda, they vacillated somewhat. I mean, initially they relied in the court of court, that's in the initial court, on what they called was their supply chain policy. And then they quickly abandoned that defense before the full court. So you know, it's been rubbished by 9 judges over the 3-year period. And you know, when you look at the judgment, it's a solid judgment. Indeed, it is not even a judgment that calls for what we call a ratio in legal parlance that makes law, that clarifies law. It's just applying old trite law, old authorities. Indeed, when you look at the judgment by the senior judge, Trevor Govan, Justice rather, it's not even reportable. So that just suggests that it's just old law that they've applied. And, I mean, overwhelmingly they've found that the ANC have not made a defense.
Sure. How far down does this order allow you to go into the ANC's coffers? I mean, this is a entity which has pleaded poverty in the past. What happens if you're not able to seize enough assets to get you to this figure of almost 150 million rand?
Well, the records and information at our disposal suggest that it can satisfy the judgment.
Right.
Ayanda, we must remember that for this very election campaign that they have not paid us, 2014, they contended in their papers that their budget was approximately 500 or 600 million rand. Indeed, their own forensic report revealed that they had spent in excess of 1.2 billion rand on that campaign. Now, we're looking in a few months for, they've already started the fresh campaign. I imagine they're going to spend well in excess of that amount. So this amount of roughly 150 million rand is really minuscule compared to what their budget is probably going to be for the new elections. But that said, We've got portfolios of property the ANC owns, so we can attach those. And then one has to remember this fact, that if they can't satisfy a judgment, then we can liquidate the party. We can bring insolvency proceedings against the party. And that does not bode well for a party going into the elections. Arguably, the IEC could exclude it from the elections.
Yeah, in fact, the IEC has said as much. They can't have an organization facing liquidation on their ballot papers. I find it very interesting that part of what they're also contending is that the people who entered into this agreement with Ezulwini weren't authorized to do so. Obviously, the courts wasn't convinced by that, but I think it's probably in the public interest to find out who those people are and, the extent of which they claimed to be representing the ANC legitimately in that agreement.
Well, the court papers set out these individuals where the one was the finance manager and the other one had been given authority in terms of a document by the then head of elections, Mr. Mbalula, where clearly the document says that the second individual is seized with dealing with the election campaign. So clearly, there was no substance to that denial.
We've been obviously going through a number of documents in preparation for this interview, and in one of them you're quoted as saying the intention here was never to embarrass the ANC, and that's why you had waited so long before things got to this point. I do wonder if the party itself, though, has reached out to you since this became public.
Ayanda, the sad fact, as I've said, is that they received the services. Okay, forget that they contend there isn't a contract. They received and benefited greatly from the services in the 2014 election. Now, here's the rub. We've never received overtures from the ANC officially. Indeed, when I say officially, I mean through their attorneys. Historically, promises were made by people high up in the ANC that they would pay. But formally, between the attorneys, there was not an offer until many, many months ago. They made a rather absurd offer. And when we suggested that they prove it, it fell on deaf ears. Now, even after the judgment was given by the full court, and clearly in my mind, in the minds of all the legal experts that we've consulted, there is no way further for the ANC. There is not a constitutional matter that they can take to the Constitutional Court, despite their announcement that they're going to do that. I can't see them doing that. Now, despite having this overwhelming victory against the ANC, we have reached out. In the last weekend, we've said to the attorneys, please make us a sensible, reasonable offer. We'll still afford you a payment plan. We don't want to embarrass the ANC. And nothing has been forthcoming. So I should mention, Ayanda, that in the preparation to the appeal being heard by the full court, after we had filed all our documents, and at a very late stage, we uncovered further damning evidence against the ANC's version. Now, it was too late to produce that to the full court of the SCA. We thought and realized it would cause a postponement of the matter, which we didn't want. My client cannot afford the matter to be delayed further. It's waited for almost 4 years to be paid. It's got huge debt. It's got many creditors knocking at its door. So we then realized we've got a good case. Let's carry on. And obviously it paid off. But we've got this damning evidence that further shows the ANC's version to be completely rubbish.
Are you able to share? Apologies there.
I don't want to let the cat out of the bag at this stage, but if they file, the way our rules work, our rules of court is, you file your affidavit. We filed our opposing affidavit to the application to lead further evidence. And when we uncovered this much later, we would have had to bring an application to the SCA for leave to introduce and supplement our initial opposing affidavit. So we were not. It would have been an exercise that most certainly would have occasioned a postponement. So we chose not to. But here's the rub. if they proceed with this application to the Concord, which I say is doomed to failure given Rule 19 of the Concord rules, which is applicable, that says clearly it must be a constitutional matter. But if they proceed, we can now produce this further damning evidence against the ANC. And you know, it's not going to bode well for the ruling party credibility in this country if that evidence further comes up.
For the interest or for the benefit of the viewer, are you able to get us a sense of the offer that the party did make to you, which you called, I think, something to the effect of ridiculous? You know, it's clearly an offer you weren't willing to take, and that's how we.
I think we can share it. I think it's in the public interest. Remember our claim, and I wanted not to say claim because it's a judgment debt, has been for 102 million rand plus interest, which to date computes to about 145 million rand and cost in excess of 5-6 million rand. Now, looking at that, the offer from them was, we'll give you 10 million rand, go away. And my response to the ANC attorney in the boardroom is quite a big muscular guy who works out. I said to him, if you weren't so big, I'd throw you out of my office by the scruff of your neck. But that is just the way, and we made it clear to them that's months ago that we would not concede on the amount that was owed to us. We would give them an infinitely reasonable payment plan. And the answer to that was, well, my client, the ANC, would have liked you to articulate something somewhere in between. Now, again, we reached out, and because they hadn't clarified the quantum that they were offering, we said, well, do we understand you to suggest that you are offering us 10 million rand plus our 140, the average of that is 75. And we articulated this figure to them, and then it fell on deaf ears. There was no response. Because possibly the desperation that my client found himself in those 3-4 months ago was that he might have accepted. They might have accepted 75 million. As reduced as that would have been, as unfair as that would have been given that they've performed, they were so desperate that they might have accepted that. Right. But again, the ANC didn't come back to us and didn't, confirm, well, okay, we're offering you 75.
Sure. I suppose, people will make of that what they will. It's also important for me to mention, by the way, on the record, while I still have you on the line, Shafique, that we did reach out to the ANC. The plan was to have this discussion with them so that they can have an immediate right of reply. And at the time of us going to broadcast, what we think is still an incredibly important story, they weren't able to offer us anybody. But nonetheless, thank you for coming on and bringing us into your confidence. Really appreciate your time this morning. Shafique Sarlie is the attorney representing Ezulweni Investments. That's this company involved in this litigation with the ANC. And Shafique is part of Sarlie and Associates. Once again, thanks very much indeed.